Good evening and welcome to Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei, with offices in Pottstown and Phoenixville. We can be reached at 610-323-2800 or on the internet at owmlaw.com. My name is Joseph Koury. I'm co-chair of our business law practice group. With me tonight are my colleagues Gary Stein and James Kovaleski. We'll be speaking about non-disclosure or confidentiality agreements and their use in different applications in various business contexts. Gary, can you start us off and tell us what a non-disclosure or confidentiality agreement is?
Yes, a non-disclosure agreement, which is also known sometimes as a confidentiality agreement, is a legal contract between at least two parties that outlines confidential material, knowledge, or information that the parties wish to share with one another for certain purposes, but wish to restrict access to or by third parties. So it is a contract through which the parties agree not to disclose or utilize information covered by the agreement. An NDA creates a confidential relationship between the parties to protect confidential and proprietary information or trade secrets. And as such, an NDA protects non-public business information.
Whew, that was a lot in one breath there, Gary, let me tell you. So I heard you say it's a contract between at least two parties. And I assume that there can be more than two parties, depending on the circumstance.
Yes, that would be right. I mean, if you're talking about sharing the information among multiple parties, you would use the same document and everyone would be a signatory to the document. However, it's most common between two parties. Generally, the party that possesses the confidential information or the trade secrets and another party, be it an employee, be it a party that might be interested in buying the business. So it's generally between two parties, but it's certainly possible to be between more than two.
And not to get too far afield, but is it again, it's a contract. Is it a document that goes one way, goes both ways in terms of the confidentiality? Is there one size fits all, so to speak?
Well, it can go both ways, but that's not common. Normally, it only goes one way. The party that possesses or owns the confidential information probably wants to get that document signed before it agrees to disclose or share that information.
That makes sense. Jim, we talked a little bit before the program about your common experience with non-disclosure agreements. Why don't you tell me a little bit about that?
Sure. Most recently, what had happened is I represented the seller of a business. They were being bought out by a larger corporation, but before we got really into the deal, what we did is we provided a non-disclosure or confidentiality agreement to the prospective buyer, because our clients were really providing them a backseat peek into, or behind the window peek, or behind the curtain peek of to all their details, their clients, the way they did business, how they marketed. I mean, everything and anything that was involved in the business, really the nuts and bolts of it. So if the buyer was going to be a bad guy, they could have potentially, and we didn't have that agreement in place, that buyer could have taken that information, could have taken a look at it, then taken that information, replicated it, and then basically recreated our client's business without any compensation being paid and really harming our clients. So it was early on in the process, but that's oftentimes you'll see being used, the non-disclosure, when there is a business transaction like that where a business is being sold.
I've certainly had that experience, and perhaps you have as well, in the sale or purchase of a business, particularly in the due diligence phase. I've seen where a party will not release tax returns, for instance, until that non-disclosure agreement is in place. And then once it's in place, you get the tax returns or provide the tax returns, and the buyer or seller, as the case may be, can take those returns to their accountant, make sure that the numbers are accurate, reflect a fair purchase price, so on and so forth.
No, great point. And actually, you brought up another great point. Usually the non-disclosure agreements you'll see will permit reasonable disclosure of the information. So the buyer there, it's reasonable for the buyer to present it to their accountant to review it, to make sure that the financials look good. The accountant may or may not be a party to that non-disclosure agreement, but the buyer in that case is going to be responsible for the accountant's action. So if the accountant's a bad guy, and then he or she disseminates that information beyond the scope of just reviewing it in that purchase, there's potentially harm to the seller, and there's potential liability under non-disclosure. So while it's permitted, and you can have your professionals review that information, you just need to make sure that they're not doing anything bad with it as a second step.
That's a good point.
And one of the key points here is, as long as the deal closes, as long as the purchase occurs, generally there won't be a problem. Mm-hmm. The key point with these documents, however, in a purchase and sales situation, is what happens if the transaction does not close and the party that shared the information is then left to do business on its own with a potential competitor who now knows certain trade secrets or other confidential information about the ongoing business.
Sure, and again, getting back to a comment I made earlier, there really is a no one-size-fits-all situation. For instance, I've reviewed a lot of confidentiality agreements in various circumstances where I insisted that the party receiving the confidential information, meaning my client in that particular situation, be able to keep at least an archival copy of information provided. For instance, if there were ever a question down the road from a regulatory body, for instance, as to what was the information, what did you do, a valid inquiry, if you will, you would want that consultant typically to be able to produce records to defend or assist, as the case may be, given the context.
Yeah, because I would think that the party that discloses the information would probably want that material destroyed if the transaction blew up and the deal did not close.
Sure. Again, no one size fits all. Now, Gary, we're not talking about non-competition or restrictive covenant agreements specifically tonight, but we did speak a little before the program about non-disclosure agreements in a similar context. Why don't you talk a little bit on that?
Yeah, primarily in the context of an employment relationship. Often when an employee begins work at a new employer, there will be a variety of documents that the employer asks the new employee to sign. First would be a non-competition agreement, setting the terms under which the employee would not compete with the employer, generally after the employment relationship is terminated. But as part of the non-compete agreement, or along with the non-compete agreement, there often is a non-disclosure agreement, a confidentiality agreement, which prohibits the disclosure of trade secrets or other proprietary or confidential information. They're all part and parcel of the same thing, and that is to protect the employer in this case from being harmed by actions of this employee, either during the employment relationship or after the employment relationship is terminated. So if an employer gives confidential information to the employee, wants to make sure that customer lists and other trade secrets aren't used in an adverse relationship to help a competitor. That's the primary goal here, is to protect one business from what we'll call unfair competition by a former employee who may be assisting his or her next employer.
And as I'm sitting here listening to you, I also thought of a non-disparagement clause, which you often see in this context as well. You want to talk a little bit about that?
Well, the only thing I can think of, I don't know that there's any law against people bad-mouthing their former employers. But, yeah, on the list, that to me would be the lowest category.
But again, no law, but contractually, and we're talking about contractual arrangements, that might be something an employer might also want to
Correct,
put
as
in
part
place.
of the package, if you will, of these particular provisions.
Let's talk about one more example of a non-disclosure agreement context. Not necessarily something we see very often on the East Coast, but again, something we talked about, Gary, before the beginning of our program tonight on the West Coast and high technology. Can you give us a scenario where you might envision a non-disclosure agreement being put in place?
Well, someone that goes to work for a tech company is going to be working with, in my estimation, a whole lot of proprietary information that's been developed by the employer and by the employees that have already worked at that employer. So I think it's really critical in that circumstance to protect the confidentiality of that information and make sure that when the employee moves on, as I said, to the next employer, that none of that goes to the new employer. Although I think this may be a double-edged sword, because if an employer presents a new employee with a lot of restrictive covenants,
Right.
non-compete, confidentiality, non-disparagement, etc., the question will be at that time, does a new employee who has a lot of bargaining power in the tech world, with engineers, tech workers being in short supply, would they say, no, I will not sign this document because it's limiting my future employment prospects down the road? And do they have enough bargaining power to decline signing that set of documents and make the employer withdraw the documents? Or, does the employer have the leverage at that point to require the execution of the documents? I think it's a good point. We're 2,500 miles away from Silicon Valley, but I think it's a question to ask, and that is, where's the leverage here? And does a new employer want to be known in the tech world as being overly restrictive to its employees and get a reputation as being unfair in terms of limiting their job prospects down the road?
It's an interesting policy question as well. And Jim, you might not be aware, I shared with Gary, the White House just published a white paper, for lack of a better word, in May of this year, analyzing the policy implications on the restraint, if you will, in our economy that can be prevalent with restrictive covenants, and maybe extend that to non-disclosure agreements in a generalized kind of way as well.
Certainly. I would think the non-compete issue can be characterized as an issue of fairness.
Right.
And restricting people's ability to make a living within a certain radius. But protecting proprietary information doesn't strike me as being unfair, because that's information that has been developed and is owned by the employer. Now, there are some exclusions or exceptions from the confidentiality obligations. Let me just run through a few.
I think we're coming up on our halfway point now, and this is probably a good time to take a break, because I think that will be a good place to pick it up, and perhaps even start with what should be in the agreement, and then what should be out of the agreement, so to speak, when we come back. We'll be back in just a moment. Again, this is Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Welcome back to Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei. With offices in Pottstown and Phoenixville, we can be reached at 610-323-2800 or on the internet at owmlaw.com. Again, with me this evening are my colleagues Gary Stein and James Kovaleski, and this is the second half of our program on non-disclosure or confidentiality agreements. Jim, why don't you tell us a little bit about what you would expect to see in a confidentiality agreement? What goes into good draftsmanship, if you will?
Sure. I think the first topic is what is actually protected by the confidentiality or non-disclosure agreement. It should be information that has commercial value. So trade secrets, designs, anything like that, customer list, tax returns like we talked about in the first half, I think all fall into what should be protected by the NDA. If they put in there the color of their walls or the color of their carpet, I don't really know if that's protectable information with an NDA. It's just there's no commercial value. It doesn't harm them if that information gets out if it's not already out, which leads me to the next thing that you see as far as the information is exclusions to the information. If something's already publicly known, if it's common knowledge that ABC Corporation has, to stay with my silly example, blue walls and blue carpet, that's public information that's not going to be covered or not going to be protected by that NDA. It's going to be an exception to it because everyone already knows it. Another common exception to that information, staying with that theme, is anything that's already known to the recipient. So if the recipient has already received information prior to the non-disclosure agreement being signed and executed, that information is not going to be potentially protected by that NDA because it was already known to the recipient. But anything that's garnered after the signing is going to be protected so long as, again, it has that commercial value. Those are probably the two biggest exceptions that I can think of, but you really have to give care to the crafting as far as what's protected, the timelines for that protection. So is it something that is going to expire? Is it something that's going to last forever and a day? You have to pay attention to that, because especially if you're the party that's receiving the information, because that's going to be an obligation you're going to have for that timeline. So if you're reviewing one that you received, you want to make sure how long are you going to be on the hook to protect that information. Another thing that's usually in there is what happens to the information that you got. Gary mentioned if the deal doesn't go through, so you've reached a point where you've decided to separate. What happens to that information? Most people are going to want to have it either confirmation that it was destroyed or returned if it was paper copies. Joe, you had talked about you had negotiated in where you could keep an archival copy, basically set aside up on a shelf collecting dust if and when a case happened. But that's going to be another major point, because if you have to destroy it, if it's 3 pieces of paper, that's not a problem. Or if you have to return it, it's 3 pieces of paper. If it's 3 truckloads of information, that's going to be an obligation. It might be a cost that's going to be borne by you if that deal doesn't go through. So those are some common things. You're also going to want to look at what are the ramifications. What happens if you, as the recipient, either break it, meaning you released information that you shouldn't have, or if you're the person that had provided it, you found out that the person that had received it has gone around your back and disclosed that information. What can you do to them? Can you sue them? Where are you going to sue them? What law applies? If you're a little manufacturer here in Pennsylvania, you're doing work for a large corporation in California, that corporation is going to want California law to apply and California courts to have jurisdiction. Well, if you're here in Pennsylvania, that's going to be a costly proposition for you to travel out there, retain counsel out there to defend that or to enforce the non-disclosure. So these are some of the common things that you really want to pay attention to when you have these NDAs in front of you.
Boy, that was a lot to chew on there, Jim. I would add that, and as you were speaking, I was thinking about it. You did hit a lot of issues. The timing nature, the duration is obviously of importance. A lot of times you'll have differing time periods even within an agreement. Certainly, trade secrets, you would think, the confidentiality restriction would survive in perpetuity. And if you match that continuing obligation to the ability to retain the archival copy, I think that would give most employers comfort. Because occasionally you'll have some pushback, in my experience, even with the one archival copy being retained, for obvious reasons, because there's a lot of confidential information in these agreements typically.
Absolutely, and I think you brought it up before. This is a contract, so there's going to be negotiations on both sides. The receiving party is going to want to try and shorten the obligations down as much. The giving party is going to want to extend those, and it really depends on leverage. I know we talked a little bit about that in the first half. All these things are negotiable, or maybe not negotiable. If you're Gary and I were joking beforehand, if you're dealing with, say, a large corporation like GE and you're a small manufacturer, you might have less leverage. But if you're dealing with a smaller corporation or smaller locally owned corporation, you might have some more leverage to negotiate some of these points. So it's all consideration. It's all things that you have to be aware of when reviewing and drafting these documents.
And I think the role of a lawyer is very important in that, because as we've been talking about, there's a lot of provisions that go into a contract like this on a whole lot of issues. Who are the parties? What kind of proprietary information does it apply to?
Yep.
What are the exclusions? Just because it applies to certain proprietary information, maybe there's an exception so that the NDA does not apply to something that was provided by a party that knew about the information and had no confidential duty not to disclose it.
Right.
So, as with any well-drafted agreement, there are a variety of provisions that may be able to be negotiated. And as Jim was talking about, enforceability issues are important. Where would the lawsuit take place? Is an injunction authorized? Usually it is, because the key here is to prevent imminent harm or harm to the employer that owns, or the company that owns the confidential information, to prevent that harm occurring to that company by others. So we have enforcement issues. We could have attorneys' fee shifting issues.
Correct.
Who pays the cost of the attorneys? An injunction proceeding is very expensive because it's a lawsuit that's compressed into a very short time period. So the legal fees are very large during that intense time period. And who's going to pay the cost of those legal fees?
You know, a somewhat related issue, and it's typically thought of as an exclusion to non-disclosure agreements, but that is legal process, a subpoena. So your employee, for instance, would receive a subpoena from some regulatory agency, to give an example. I think most employers would want to be able to assume, to the extent possible, defending that subpoena, for lack of a better word, which would be on their dime, so to speak, but they would be able to control, perhaps, how that information is disseminated or not disseminated.
And they'd have notice of the subpoena, they'd have an opportunity to interpose an objection or otherwise prevent the information from being disclosed initially.
Correct. That's exactly my point. Are there any other details you can think of that you would want to add? Inclusion, exclusion, remedies along those lines, Gary?
No, I think we've covered them fairly well. I think the kind of information probably should be dealt with very specifically. For example, sales and marketing plans, manufacturing processes, customer lists.
Sure.
We don't necessarily, have to be talking about a company in the high-tech field. Any kind of private information that is useful or critical to a company can be protected by a non-disclosure confidentiality agreement. And part of the issue in terms of negotiating the terms is what really is proprietary information.
Sure. Any practice pointers you might want to add, Jim?
As far as practice pointers, just make sure you're using them. If you are a business that is selling, you're an employer that is going to be giving an employee some highly sensitive information, or if you're bringing in an independent contractor that's going to be doing work for you or some sort of service provider, you really need to be thinking about using these documents because they can be protective and they can be effective in protecting that information. So just make sure that you're using them when appropriate, and that if you're receiving one, make sure you're reviewing it and you're understanding what your obligations are, because like we talked about, you might, Joe, you brought up the point that was in my brain. If you're the person that had received it, you received that subpoena, your initial response is going to be, well, I need to give this information. But you might have obligations under that NDA, the give notice, like Gary mentioned, within so many days of receiving the subpoena. So it's important to know what's in those documents and your obligations so that you meet them, so you don't find yourself in trouble, in more trouble or less trouble, depending on the situation, but so you don't find yourself having an issue for failing to meet those obligations.
Any final words from you, Gary?
No, I think this is it's probably an overlooked issue. It's the kind of situation in an employment relationship where a new employee may be given a packet of documents, may not even read the document,
Right.
And then find that his or her course of actions down the road after they've left this employment are being impacted by a document that they may not even have a memory of. They could be sued. The new employer can be sued. So they could have very devastating consequences down the road. For a new employee, I think it's something to be treated very seriously. Similarly, for a company or an employer in this situation, again, we could be talking about information that's critical to the success and the ongoing commercial activities of this company. And this is a good way to protect proprietary information from being misused down the road.
I agree. And obviously the devil is in the details, and it may sound a little self-serving, but anytime you're dealing with contractual matters such as this, where the devil truly is in the details, you would be well served to have legal counsel advise, for sure. This has been Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei. Again, with offices in Pottstown and Phoenixville. We can be reached at 610-323-2800 and on the internet at owmlaw.com. Thank you for joining us this evening.